Good morning, Mr. Pretorius. Good morning, everybody.
Morning, Chair.
Before we start, I just want to announce that my decision in regard to Mr. Moyane's application for leave to cross-examine Minister Gordon will be handed down on Tuesday next week at 9:30. Notification will be sent by the acting secretary to the parties.
Noted. Thank you, Chair.
Are you ready?
Yes, we're ready, Chair. May we continue?
Yes, yes.
Thank you.
Thank you.
Mr. McBride, before we adjourned yesterday afternoon, we were at paragraph 27 of your statement. You were explaining to the Chair that you had certain concerns that you wished to raise with the oversight body of IPID, the Parliamentary Portfolio Committee on Police. You said that you had contacted Mr. Francois Beukman, the chair of the Portfolio Committee, and requested that you be allowed to address them to clarify certain issues. You told the chair that Mr. Beukman declined your offer to speak to them, and in support of his declining your offer, he cited the sub judice rule.
That's correct.
Whether that is an appropriate recourse to the rule of sub judice is another question we needn't go into with you now. But is it correct, as you said, that subsequent to your request, the Minister actually addressed the Portfolio Committee?
Yes.
Would you tell the Chair about that, please?
At some stage, the Minister addressed the Portfolio Committee and also the media, and dealt with his perception or understanding or version of the whole so-called rendition saga. And he did a presentation to the Portfolio Committee meeting, and the angle of the presentation was to say that the lack of concern for the possible death of the Zimbabweans was an indication of insensitivity and undervaluing black lives. That was the presentation, which was contained quite strongly there, and words like dehumanization and so on. Now,
I just want you, if you don't mind, just to go back that sentence about what he said. I just want to make sure I hear it.
Okay. If I could just go to the annex, the actual presentation.
Yes. Oh, okay.
It's at page 1333 in bundle Y, small letter D. It's the first document in file D, page 1333, right in the front.
Did you say YD, Mr. Pretorius?
YD.
Okay, and page 133.
1333.
Oh, okay.
Thanks, Chair.
Yes.
So this is the presentation that the Minister did for the Portfolio Committee. So,
Perhaps we should deal with the background before you get to the detail.
okay.
Just those first 3 paragraphs on page 1. If you could place those on record and then deal with the detailed answer that you give.
So his first point on background was that he was inundated with files of alleged misconduct, corruption, and atrocities within the South African Police Service. And he says, as the minister with his oversight role over SAPS and DPCI, derived from the Constitution, he felt duty-bound that he could not ignore these allegations. In October, he says, I established a reference group to look into these allegations. The reference group provided me with the first draft report in 2014. Among the issues brought to his attention was the illegal arrest or unlawful deportation of Zimbabwean nationals. And his next point, he says, 2 Zimbabwean nationals who were unlawfully handed over were subsequently murdered allegedly by Zimbabwean police. And then he says he was concerned that members of DPCI were involved in smuggling out from the Republic human beings, whether South Africans or not, in order for them to be tortured and killed outside the Republic. Then he says that would mean our constitutional democracy is in danger and the rule of law subverted. He says he was reminded about apartheid-era cross-border raids in which freedom fighters were abducted, kidnapped, and killed without a trace.
Mr. McBride, my invitation was just for the first page. You can deal with the paragraphs that you want to deal with now. I'm not sure it's necessary to go through the whole presentation, unless, of course, you want to.
Not necessary, Chair.
Yes. From my part, you had made a statement, a sentence in what you had said that I hadn't heard correctly, and I just wanted you to repeat that so that I understood it.
So, Chair, on page 1343.
Yes.
He gives a human rights background and institutional arrangements, and he speaks to rights.
Yes.
And then on 1344,
Yes.
he deals with the dehumanization of blacks in general and Africans in particular. And he speaks about the establishment of the active unionist South African state as it developed. He continues on the next page, covering colonialism, the Land Act, the racism and apartheid era practices, and then he contrasts that to had the lives of white people, the debate, in other words, he's referring, I would assume, by extension to the guys that were illegally repatriated, that if they were white people, the debate and headlines would have been about human rights. And then he goes on to the defense of human rights, and he quotes, ironically enough later, Helen Suzman. And my issue is I have no problem with all of what he says. The context in which he says it is a very emotive, emotional, and painful issue for this country. And to kind of extend that and somehow assume that Dramat and McBride are responsible for it. Been two freedom fighters who had served prison time for their commitment to the fight against apartheid, and to indicate that against the background of the abuses and the dehumanization of apartheid, I think was very low, and it also showed a tendency by him to use any method necessary to have his way, including innuendo and suggestions which paint a picture which is exactly opposite to the truth. And if I can just carry on that, myself and Dramat were willing to lay our lives down to end dehumanization and injustices. And we were prepared to pay the ultimate price for that. And just whimsically, in a spurious way, we are now somehow made to be the personification of all that was evil with apartheid. It's not only malicious, it's orchestrated, and it was a good sign of things to come. Thanks, Chair.
Thank you.
That against the background in terms of which you were refused an offer to address the Portfolio Committee, which is the direct supervising body, parliamentary speaking, of IPID. Is that correct?
That's correct.
All right.
Did you ever have occasion to confront the chairperson of the Portfolio Committee afterwards and ask him how the so-called sub judice rule could have prevented him from allowing you to address the committee, but not prevented him from allowing the minister to deal with the same issue?
No, Chair. What I did is to try and find out about his background. So I went to ask people who were his colleagues in the National Party about him, and would he perhaps agree to a sit down and discuss about it. And they told me that the man is only for himself. So against that background, there would be no way we could have a sensible human being discussion of what had happened, what had transpired.
Can I ask you, or may I ask you, Mr. McBride, to go to Annexure J, page 448. That is in bundle B. Why B?
What's the page number again, Mr. Pretorius?
Page 448.
Thank you.
Okay, I'm told very sternly by my junior chair that it's not J, but I'll check that independently.
Oh, well, all I can say is that I see a divider marked E. I'm only saying what I see. Your junior is looking at you.
Quite justifiably, Chair.
As if to say, you hear. Yes.
Let's just go to J.
Are you
If you would
finding
bear
it,
with me a
Mr.
moment,
McBride?
Chair, please.
Yes, Chair, I've just found it, Chair.
Okay.
Okay. Then I've got to go to 448. I'll come back to those references, Chair.
Okay, so we should put them away for now.
Yes, please. Let's go then for the moment to paragraph 29.
I have a Chair.
You talk there of your suspension by the minister. Who replaced you in an acting capacity?
Mr. Israel Khamanyane replaced me in an acting capacity.
And would you tell the Chair, please, about how the Worksman's report came into being?
There was, it's the minister's office who appointed the Worksman's company. I'm not sure the exact sequence of events who did the actual appointing. But at the stage when Worksman tried to contact IPID, they attempted to circumvent myself at that stage before suspension as the executive director. And on 2 occasions, they sent an email with the wrong email address of me, whereas the email address for Mr. Kuba and Mr. Sissoko were correct. So with mine, instead of saying .gov, they would say .co. And after being alerted to the fact by Mr. Sissoko that they had put the wrong email address, they then repeated it. They just spelled the McBride in my name wrongly. So on 2 separate occasions, in attempt to speak to Kuba and Sissoko, my view was that there's an attempt to circumvent sending it through me. During that same period, Mr. Kuba got calls from the minister and the minister's assistants directly to say he must speak to the Worksman company. And that was after I was suspended. And they were also instructed by Mr. Khamanyane to go to Worksman. For me, it was necessarily suspicious, from my interpretation, the way I viewed it as an attempt to cut me out of the process of Worksman. And the fact that the minister is getting involved himself in getting Mr. Kuba to go to Worksman's. And on paragraph 36, I deal with that.
All right, you fast forwarded in your statement to a significant degree. We'll come back to that. If we could just follow the sequence in your statement, particularly at paragraph 29. You refer to the Worksman's investigation in the record of proceedings before the Constitutional Court. Is that correct?
That's correct, yes.
So if we could go to page 875, please.
Is that in the same bundle?
Yes, sir.
875.
875.
Thank you. Well, my last page in the same bundle is for something. Is it B? Okay. YB, are you able to find it? Look for ones that is written YB, Mr. McBride.
Yes, YB.
Yeah, page 875.
Chair, there seems to be a problem with the pagination that may have been changed, and I would need to check that. I'll come back to these references in due course.
Okay.
So I won't go there now.
So we mustn't use them now.
Yes, please. You take issue in your statement with the compilation and outcome of the Worksman's report.
Yes.
And you go in your statement to some detail and to some trouble to justify your view of the Worksman's report and its outcome.
Yes.
Now, I'm not sure whether from the point of view of the legal team that detail is relevant to the bigger issues that you wish to place before the court, or before the chair rather, because they are in a sense your opinion of a written record.
That's correct, Chair.
But I don't want to deprive you of the opportunity of telling the chair what you want to tell the chair. Do you have any comment on the division between the detail and the big picture?
Yeah, absolutely. Overall, for me, it's the pattern that happened. Sorry.
Your microphone, please.
Okay, my apologies. The aspect for me is the larger picture, which I'm testifying about, the pattern that was witnessed in other departments with different law companies, against the background of even auditing companies, law companies, and publicity companies getting involved in facilitating certain maladministration and perhaps criminal stuff in the entire administration of government, including SOEs. My issue is dealing with law enforcement in a broader scale. So if anyone wants to take issue on the specific opinions I held about specific conclusions that I recorded at the time about Worksman's, I'm willing to deal with any of it, but those are details. It's my opinion, it's a firmly held opinion, and I placed it before the Constitutional Court and the High Court. It was never challenged at any stage, but I'm willing to assist if anyone wants to inquire about the detail of that.
Right. Paragraph 30, you talk about communications or attempted communications between Mr. Kuba and a person in Minister Nhleko's office. Would you tell the chair about that, please?
Thank you, Chair. Mr. Kuba reported having received multiple calls from Minister Nhleko's personal assistant. And at some stage, Minister Nhleko called Kuba and said he should come to Cape Town and the ministry would cover the costs of his flight to Cape Town, even on a weekend. And for me, when it was reported to me, as I do now, it was very strange and a sign of desperation to somehow prove the lie that was being created, to start a process and put pressure on people. Kuba would later be suspended, disciplined, and dismissed on spurious grounds. And for a minister, and because in the culture in South Africa, in the culture in the civil service, we respect seniority, and we view a minister as the most senior in the department, even if we are independent. So we always defer to ministers a lot. And for the minister then to misuse that, to attempt to contact directly officials in the department is basically an abuse of the respect that civil servants show to seniority. And it could not have been for a good reason. It couldn't have been for some reasonable purpose. Why wasn't he just happy to allow processes to continue? He has now appointed Worksman. Let Worksman go ahead. Perhaps Kuba doesn't want to talk to Worksman. That would have been his right. Why would the minister want Kuba specifically to talk to Worksman? And then later on for the Worksman report to be used against Kuba and Sissoko and myself, not only in disciplinaries, but as a basis for a criminal case against us. So the whole notion of respect for the rule of law and equality and fairness and avoiding dehumanization of black people as per the presentation in Parliament, Minister Nhleko just throws it out of the window like this, and respect for processes and rule of law. Just like this, without a blink of an eye, he's willing to use processes to achieve his ends.
Just for the sake of completeness and for whoever may be listening who has not or might not be familiar with a lot of background to these things, just state again what Workman's mandate was. What had the minister asked them to do? What was their brief, in other words?
Chair, if I can just find the brief is somewhere in the bundle.
Oh, but not necessarily that you need to be accurate in terms of how it is, but your own understanding, subject to whatever is written in black and white.
Well, thanks, Chair. It was there was a broad section to look at misdemeanors or misconduct in DPCI, and there was a section to look at what happened. This is a minister asking about the criminal justice system. What happened to a docket when it was at NDPP, at the NPA? What was the process, and what role did Kuba, Sissoko, and McBride play in altering the report? And it's on the basis of this that we start to run into trouble. I can deal with the details.
Yeah, no, I thought because you were, in your evidence, you were criticizing the minister for not allowing process to continue. It's important for everyone to know what the Workman's mandate was, at least as you understood it.
Yes.
Yeah.
DCJ, Chair, we were to come to that, but perhaps it's convenient that it be dealt with now.
Yes, okay.
Just by way of background, you're dealing in your evidence with two separate sets of facts. The one is the so-called rendition saga, which ultimately led to the termination of services in one form or another of Generals Dramat and Sabia.
Yes.
And you testifying to that set of facts. You're also testifying to certain facts which led to the termination of service or the suspension of yourself, and Messrs. Kuba and Sissoko.
Yes.
That's a separate set of facts which revolves around what IPID did or didn't do in relation to its reports.
Yes.
And that is separate from the crime intelligence investigation, the crime intelligence reports, the NPA, and what the NPA did with all the evidence. It seems that you were called to account for your participation in that chain of investigations and activities regarding the rendition saga investigation. But those are two separate issues. The Worksman's report, as I understand it, dealt principally with your role and function in relation to the IPID investigation, or the IPID participation in the investigation, or the IPID part of the investigation, into matters related to the rendition saga.
That's right.
The terms of reference appear at page 1375. Which is bundle D.
That's YD.
YD.
Page
1375.
75. Thank you.
They appear in paragraph 5 of page 1375.
I don't have paragraph 5 at page 1375 of Exhibit 2.
My apologies, Chair. You have paragraph 2 headed introduction.
Yes, I do.
And then paragraph 2.1, terms of reference for the investigation.
Yes.
And then in quotation marks, there's a paragraph 5. I'm sorry, I should have been clearer.
Okay, all right.
Which
Thank
reads,
you.
your terms of reference in the investigation are the following. Would you like to put that on record, please?
Have you found it, Ms. McBride?
Yes, sir. I have.
Yes, okay.
Your terms of reference, this is Minister Ntlego to Worksman's. Who and under what circumstances was the original report altered, or how the second report came about with both reports signed by the same person, Mr. Kuba? And second one, whether any misconduct or offenses has been committed, and if so, by whom? Whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant Dramat, he says a Major Sibia and any other officers mentioned in the original report. The circumstances, that's 4, under which the report and the docket handed in the NPA, and what happened to the docket whilst in the NPA's possession. Any other matter that might come to your attention during the investigation which is relevant to your conclusions.
We can, and it may be necessary because you've made fairly strong allegations in relation to this report and the signatories to this report, deal in some detail with the content of the report. We may have to go there. We'll consider it as a legal team. But just for the present, to fast forward to page 1443.
I have the check.
In essence, you've given evidence that further investigation was done and a complete report was signed by yourself and presented to the NPA or the DPP within the NPA. Do you recall that evidence?
That's correct, yes.
And what Worksman's were asked to investigate and did investigate was essentially the differences between what has been termed the provisional first report and the second report.
Yes.
And how that came about and whether there was any misconduct in relation to the changes between the first report and the second report, and secondly, whether there was any criminal conduct in existence in relation to the changes between the first and the second report, or the additions.
Yes, yes.
At paragraph 6.4.5 on page 1443, you are mentioned.
Yes, yes.
The report concludes, in the absence of any information as to which of the 3 co-signatories were responsible for the deletion of information from the first report, we recommend that Kuba, McBride, and Sissoko be charged criminally for defeating the ends of justice or obstructing the administration of justice, and that disciplinary charges be brought against them in their capacity as employees. What is your comment on that?
What the report is saying is, because we don't know, let's charge all of them.
There may be some other basis, but
Yeah.
it may be necessary to go into some detail into who's right and who's wrong in the
Yeah.
report.
Yes.
Whether that affects the other evidence you've given at a high level is open to debate.
So, but your comment, Mr. McBride, is, as you understand it, the effect of what they are saying here is, we don't know who among the 3 altered the report. But then they must all be charged, both criminally and in terms of disciplinary steps. That's what you are saying. That's what you say it actually boils down to, that paragraph.
That alone, Chair, is a problem. But the other issue is, whether it was changed lawfully or not is irrelevant to them. Whether not to have changed it would have been a bigger problem is irrelevant to them. The fact that something was changed, and from our investigation, we can't see who changed what. But unwritten word is, well, we can't really nail McBride yet. Even in our own misunderstanding, let's charge them all. They'll cast the net wider. Even from their own misperceptions, which... And if you also look at the other recommendations, I mean, they should not be involving himself in what the NPA does. As a private legal company, what the NPA does, and a private legal company does not recommend criminal charges to state officials whose job is to investigate. So they are double thinking the investigation. They are questioning the investigation carried out by an independent body whose task it is to investigate with limited knowledge. And in a strange circumstances where they come into the scene. Now, I'm quite aware that Worksman is an international company. It does a lot of good work. It's well respected and all of that. But my view in this instance, they got it wrong. And they jumped to conclusions. And it clearly to me, and now we can go into the details, it was a hurried report. And it appeared there is a timeline and things needed to be done on time. And that is why the minister was even phoning Kuba. I was on suspension when I offered to go before that panel of Worksman and answer questions. And the lawyers at Worksman asked whether I would not require a lawyer. And I said, I don't need a lawyer, I've done nothing wrong. But the tension in the room was felt, you could feel it was tangible. And we, based on how we reached there, myself, Kuba and Sissoko, we were suspicious about the whole Worksman report. This is just a process to ultimately nail us in the end. So we did go there with apprehension.
You didn't say so expressly, but I think from what you were saying, you were confirming that my understanding of what you were saying about that paragraph that was read to you was correct. My understanding, I take you to be confirming that what I put to you as your understanding of it, or your comment on it, was correct?
Yes.
Yes, okay,
Chair.
all right.
Yeah, yeah.
Because I just wanted to make sure, but you talked about it further, but I want to know whether I was correct in understanding it. Can I also ask this? I think one of the things you have said is that the workmen's seem not to have bothered to ask the question to the extent that there may have been an alteration of the report. Was that alteration lawful or not lawful? That's one of the things that I think you are saying. Is that right?
That's correct.
So you are saying they didn't look into an issue that was critical, because if the alteration was correct, there would be no basis to say anybody must be charged criminally. Or if the alteration was lawful, there would be no basis to say somebody must be charged criminally.
That's correct, Chair.
And you say, on your understanding of the report, they ignored that very important issue which they should have considered.
That's correct.
Okay.
Yes. Chair, in fairness to Worksman's, of course, it may be necessary to interrogate the whole issue in a little more detail.
Yes, no,
we will come to that.
No, I accept. I just wanted to make sure that I understand what his thinking is about the report. Yeah.
But just at the higher level, your evidence relates to a matter of general import to the terms of reference of the Commission, and that is the manipulation of procedures and processes in order to,
Yes.
in essence, as you say in your evidence, capture the law enforcement agencies. At a higher level, the Worksman's report was the basis for criminal charges against you.
That's correct.
What happened to those criminal charges?
The Chair, they were withdrawn as and the words of the prosecutor were to the effect, there isn't any evidence to sustain a prosecution.
Right.
Why were we charged in the first place? In addition, there's a disclaimer on the Worksman's report. The author of the Worksman report refused to testify. And his view was, well, it's hearsay of hearsay. And I've got a disclaimer saying it's not to be used in any litigation. So ultimately, what was the purpose of the report if it could not be used in litigation? And even though there was that disclaimer, those who decided they are going for us and they will charge us and discipline us didn't care. And so it was withdrawn against us.
Yes. These events eventually also led to your suspension. Not necessarily the Worksman's report, but the events which Worksman's investigated.
So I was suspended before
Yes.
the Worksman's interview. I was on suspension when I did the virtual.
Yes, that's why I say
Yeah.
the events which were dealt with in the Worksman's report,
Yeah.
in fact, led to your suspension. Although you were suspended before Worksman's dealt with the issues in their report.
No, Chair. I was suspended before Worksman's report.
Yes, now I understand that. That's what I'm saying.
Yeah.
So, Worksman's dealt with certain events
Yes.
in their report. Forget Worksman's for the moment. Those events led to your suspension. Are you following what? Am I making myself clear, or am I not making myself
maybe
clear?
let me assist. When Workman's was asked to do what they were asked to do, were you already on suspension?
At the time they were requested to, when they were given this brief, I was not yet on suspension.
You were not yet on suspension. Are you able to recall how long after they were given this brief you were suspended? More or less. A month, 2 months, 3 months?
A month.
About a month or so. Before you were suspended, had you had any interaction with them within that month or so after they were asked to do the work?
No, Chair, except the purported attempt to make contact with me
Through an email?
through a defective email.
Yes, okay. And their report, how long after you went on suspension did it come out, if you are able to tell? 3 months, 4 months, 5 months, 6 months?
It came out after the interview was in April.
Yes. Your interview with them?
That's correct, sir.
Yes.
And the report was leaked to the newspaper the weekend before I was going to appear in my first disciplinary.
Yes, okay. The events in connection with which you were suspended, as you understand them, were they some of the events that were dealt with by them in their reports?
That is correct, Chair. So I was suspended before an investigation.
Yes,
Yeah.
yes. Okay, all right. Mr. Pretorius, I don't know if that has helped.
Yes. Let's just summarize. You've testified about the rendition saga. You may revert to it in due course, correct?
Yes, Chair.
IPID investigated that, or was part of an investigation
Yes,
into
that's
the
right.
rendition saga. During the course of IPID's work, a so-called first report or preliminary report was prepared.
That's correct, Chair.
You've explained the circumstances in which and the necessity for the preparation of a final report which you signed. Is
That's
that
correct.
Whether by way of addition or whether by way of deletion, whether properly or improperly, we know that the second report differed from the first report.
Could you kindly repeat the last
Okay,
part?
let me put it this way. The second report differed from the first report.
That's correct.
At issue is whether that was done properly and lawfully.
Yes.
Right. You have given extensive evidence to explain your view that it was lawfully, properly, and necessarily done.
That's correct,
In
sir.
fact, you've gone so far as to say that had the second report not differed from the first report, that would have been unlawful and improper.
That's correct,
Now,
Chair.
that is an issue for debate which we may have to go into because there are different views on that. The investigation resulting in the first and second reports, ultimately, the facts relevant to that led not only to criminal charges being brought against you, but also to your suspension. Am I correct?
Indeed, Chair.
Right. Now, you've said that in relation to the criminal charges, they were withdrawn because you say the prosecutor's view was that there was no case. Correct?
That's correct, Chair.
Now, I'm interrogating the suspension aspect. Right? The suspension, for the reasons that we've now clarified, the suspension was ultimately declared invalid by the Constitutional Court for a number of reasons.
That's correct, Chair.
Principally, that given the constitutional independence of IPID, the Minister of Police would have had no power to suspend you at all. Correct?
That's correct.
Right. Did anybody else then purport to take disciplinary action against you? In other words, did the Minister say then, I've been told by the Constitutional Court that I can't suspend or discipline you, but someone else will? Did anybody else take up the cudgels against you?
No, Chair. After the Constitutional Court decision, the Minister attempted to scupper my return to IPID through two ways. One is, in fairness, the provisions of the Constitutional Court judgment were such that independence doesn't mean insulation from accountability. So to make the whole process fair, if there is a case for the Executive Director to answer, we will give the Minister and Parliament 30 days, working days, to deal with any disciplinary that is required. Parliament did not deal with it. So that's the one issue. The second issue is the Minister made a complaint, the acting Executive Director made a complaint to the Public Service Commission about this matter and other matters, in which they then tabled a report of the Public Service Commission to Parliament. Ultimately, that report and its recommendations was withdrawn by the Public Service Commission.
Mr. Pretorius, I don't know whether I missed something. We're now talking about what happened after the outcome of his case in the Constitutional Court. I don't remember us looking at the letter of his suspension, seeing what reasons were given by the Minister for his suspension. But also I want to know, Mr. McBride, between your suspension and General Dramat's suspension, which one came first? Was it not Dramat's one?
That's correct, sir.
Yeah, so also with regard to that, I don't know what your plan may be. I would prefer that we deal with them in the sequence in which they happened and we exhaust them, like we exhaust Dramat's suspension and then move to his, and so on and so on.
Chair, indeed that is the plan, and that is as it appears in the statement. My concern was with some potential alteration in the numbering of those excerpts that I was going to put, particularly to put Dramat in the proper sequence.
Okay.
But the purpose of this evidence is somewhat different. Or the purpose of the questions is somewhat different. It's just at a high level to place the Worksman's report in its proper context. In other words, to say that even given the Worksman's report and even given the suspension and laying of criminal charges against Mr. McBride, they ultimately came to naught. That's just the point I wanted to make. It's taken a long time to get there, but you will forgive me for that, Chair.
I understand that, but from what he said to me when I asked him the questions that were meant to clarify what you were asking him, it's clear that the actual report came after his suspension. So I'm just saying, for me, it would be very helpful if we deal with those events, if possible, the way they followed each other. Of course, there may be good reasons sometimes to change that. It's just that once we deal with what happened after his success in the Constitutional Court, when we have exhausted how he was suspended, what the reasons were that were given, it's a little difficult to follow.
I understand, Chair.
Yes,
I understand, but
okay.
the sole
But I
purpose-
understand your concern about sorting out the pagination. That I understand. So as long as you are alive to my concern, it's fine. Let's continue. At a certain stage, it will help if whoever is listening can just see the sequence properly.
Yes, Chair.
And I think it is important it may be important to look at the sequence because of events, which event came after which event, because there may be significance even in why that particular event happened after that one.
The judgment of Prinsloo J in the matter between Helen Suzman Foundation and the Minister of Police at page 439 in bundle YB is a useful record of the time sequence in relation to General Dramat.
What page again?
448.
Thank you.
In paragraph 10, the judgment, which is a recordal of events, and you would know these facts from your own knowledge. The judgment reads, on 23 December 2014, the Minister wrote to Dramat informing him that he was placing Dramat on precautionary suspension with full pay and benefits with immediate effect.
Sorry, Chair, I don't have the correct page.
All right. Just help.
It's Exhibit Y, B for Beatrice, and it's at page 447. Of course, where we say 447, or did you say 448? 447, I think you said.
448.
Or 448, I'm sorry. We are leaving out the 0 before 4, so if you look at it, it will read 0448, but we're just saying 448.
I have it, Chair. Thanks.
Do you want to repeat your question, Mr. Pretorius, on paragraph 10?
Paragraph 10, it appears that on the 23rd of December 2014, the Minister wrote to Dramat informing him that he was placing Dramat on precautionary suspension with full pay and benefits with immediate effect. Do you see that? Are we on the same page? Apparently not.
It's 447.
No, I'm sorry, 448.
448.
I got it wrong, Aidan. Said 447. It is 448.
I have it now, Chair. Thanks.
Paragraph 10.
Okay, have it.
I think Mr. Pretorius was referring to that paragraph and saying you would know those events yourself. You want to say something about what is said in paragraph 10?
Is it correct that the precautionary suspension was at least initiated on 23 December 2014 in respect of General Dramat?
That's correct.
Do you know from all the litigation and your own facts firstly, whether the Minister relied on any IPID report, and if so, which?
According to the Minister, he relied on an IPID report which could only have been the preliminary report.
Do you know whether the Minister relied at all on the signed report or the report signed by you as the final report?
There is no way he looked at it, otherwise he could not have suspended him on the grounds of that recommendation report, the final one which I had signed.
Well, unless having looked at it, he thought, or he was not persuaded by it, maybe. Is that a possibility, as you see the matter? Or you think he definitely did not see it, otherwise he would not have acted the way he acted?
Chair, if you can be allowed to answer it,
Yeah.
it differently.
Yes.
If he was concerned at all about the final report, and if he had somehow received the preliminary report, he could have called me in and indicated, I've read this report, the final one, which you've given me upon my request. I notice it differs with the other one. Kindly explain, since you provided me with this report.
And he did not do that.
He did not do that, sir.
Yes,
In fact, he never did that ever about the rendition issue.
yes. But you have said that there exists somewhere a written proof that the second report was delivered to his office.
Yes, that's correct, Chair. I've attempted to contact
Yes.
my former colleagues in IPID, but without success.
Yes. Okay. No, I'm sure the commission will try and get that. So, but you have no reason to. You know of no reason why, if his office did get it, why it wouldn't have been given to him.
No, I have no ideas.
Now, there will be direct evidence of this later, Mr. McBride, but would you go to page 490?
Sorry, Chair, if I can just, before that,
Yes.
to follow it up. The Minister had requested the docket and the report, and had given me 2 days to provide it.
Yes.
So there was a deadline.
Yes.
We took it and we've got notice. If it was not received, he would have asked me. I gave you 2 days.
Yes.
Why haven't you given me the report? If there was any chance he did not receive it.
Yes. Yes. And if he put that kind of deadline, it must mean it was very important for him that he receives it and that it was also urgent.
That's correct, sir.
And one would have expected that if he didn't receive it, he would have brought that to your attention in one way or another to say what has happened.
Absolutely, Chair.
Okay.
Perhaps before we return to the sequence of events, I'm going to hop out of that sequence, Chair,
Yes, okay.
to deal with the notice of suspension about
no,
which
that's
you've
fine.
asked. That appears at page 186 of the first bundle, in which your statement is bundle YA.
What's the page number again?
186, Chair.
Thank you. Have you found it, Ms. McBride?
Yes, Chair, I have, yes.
Yeah.
Right, I'm going to ask you, because although this is at a level of detail that may or may not affect the general points you are making in your evidence, to read it onto the record and to comment on each paragraph that you wish to comment. I know it's going to take time, Chair, but perhaps it's necessary.
No, that's fine.
Would you start at paragraph 1 and deal with it, please?
This notice serves to inform me that I intend placing you on precautionary suspension with full pay and benefits for a period not exceeding 60 calendar days.
Right, now, this is some months. This letter is sent, it appears on page 188, or it was signed at least on the 10th of March 2015. Some months after General Dramat's precautionary suspension. You see that?
Yeah, this is, in terms of sequence of events, this is after Dramat was suspended.
Yes. Some months after.
That's correct, sir.
Yes. So if you could go back, please. To paragraph 2 on page 186.
There are serious allegations which have been made against you, some in the media, prima facie alluding to possible acts of serious misconduct by yourself as head of the IPID.
Yes, paragraph 3.
On 8th of March, you were appointed as Executive Director of IPID in terms of Section 6 of the IPID Act of 2011.
Right. That's 8 March 2014.
Yes, that's, you used the wrong date, yes.
Right, if you could go to paragraph 5.
He says, during or about January 2015, you are alleged to have breached your statutory responsibility to act with independence and impartiality in that you informed Lieutenant General Dramat and Major General Sabia through their legal representatives in writing that they had been cleared by the IPID investigation regarding IPID's investigation into the illegal rendition of Zimbabwean nationals by the officers employed in the DPCI.
Paragraph 6.
When you did so, you allegedly knew very well that IPID did not clear Lieutenant General Dramat and Major General Sibia because you had in your possession the original report by IPID dated 22nd of January 2014, which recommended that Lieutenant General Dramat and Major General Sibia be criminally charged with kidnapping and defeating the ends of justice.
Right, and paragraph 7.
When I invited you to explain your conduct regarding the aforesaid, you failed to disclose to me that there were 2 IPID reports, the conclusions of which were contradicting each other.
Right, now let's just stop there. What the Minister refers to here as a communication from IPID to Lieutenant General Dramat and Major General Sabia. Was such a communication delivered?
Yes, the legal representatives were informed, and at least one and possibly 2 of them had requested in terms of Access to Information Act, what the status of their clients were.
Right, and you responded?
Yes, and as the investigation had been completed and submitted, there would be no prejudice in informing them of the status of their clients.
Rightly or wrongly for the moment, paragraph 6, it's apparent that the Minister was referring to the first report and in a sense relying on the first report.
That's correct. Just give me a moment, sir. Now, if I can just say, Chair, that's what, on 6, what he purports to say. If you remember the letter that he requested the docket from me, if we go back there, he asks for preliminary as well as final reports on that matter. Now, what he had in mind, whatever it was, we gave him the final report. Whatever he had in mind, there was he was quite clear that there was a series of preliminary reports. He was aware of that at that stage for some reason.
Now, you are talking about at what stage exactly? Was it at the stage he sent you a letter giving you 2 days within which to give him the report? Is that what you are talking about?
That's correct, sir.
Okay, and you are saying that the communication,
Yes.
whether it was in, I think it was in writing, you said?
Yes,
to
yes.
the letter. Are you saying your recollection is that the letter made it clear that he was aware that there was a preliminary report
Yes,
and a final report?
That's correct.
Or at least that there were 2 reports?
Yes, you see,
Yes,
but
you say that letter made it clear that he was aware of that.
Subsequently, in analysis, we saw now here is where he tripped himself up. Because when we responded, we gave him the docket, the full docket and the final report as submitted to the NDPP. But his intention to say he was not aware that there was some preliminary report, which I at that stage was not aware of. Because nobody had told me there was a preliminary report until almost 9 months later, when it leaked out that there was a report. At the stage, we finalized the submission to the NDPP. There was 1 report in front of me. So those,
The final report.
that's all I had seen.
Okay, maybe just so that we understand. My impression yesterday was that when you prepared the final report,
Yes.
you were aware that there was a report that had been sent to the NPA that had been signed by Mr. Kuba only. But what you are saying now is, as at the time of asking Mr. Kuba to do further investigations,
Yes.
and as at the time of signing the final report, you were not aware that there is a report that Mr. Kuba had sent to the NPA. You were only aware that a docket had been sent to the NPA. Is that right?
That's correct, sir.
And you have made the distinction that there is a docket and there is a report.
Yes.
And I think yesterday I asked you whether when they are submitted, the docket and the report are submitted at the same time. Yes. But you made the distinction that there's the docket and then there's the report. The report is an opinion, as you put it.
In addition, Chair, I had not known that in the verbal briefing that there were actually reports as a way in which IPID did things attached to dockets. Until that report that Kuba gave me, and signed by Kuba and Sissoko. So I was not aware that there are reports that go in, because I was new in IPID, and that IPID does it this way. Never mind knowing about a preliminary report, in addition to the docket, can change its findings. It would just be a common sense thing later on that occurred to me, and when I became aware, this is how it's practiced.
So when Kuba gave you a briefing, you
Yes.
remember you told us that you asked for an update on all high-profile cases.
Yes, yes.
And Kuba, among others, gave you an update on the so-called rendition matter.
Yes.
He did not say there was a report he had sent to the NPA already.
We spoke in terms of docket and
Yeah.
where the investigation is.
Yes, yes. So, but he told you there was a docket that was sent to the NPA.
Yeah.
And it may be that in his mind, if he talked about the docket, they included the report as well.
Yes.
But your own understanding didn't include a report
Yeah.
at the time.
At the time of the briefing,
Yeah.
there was no physical report,
Yeah.
and neither was I aware that that is a practice at that stage.
Okay.
This is my first week
Yeah,
on the job.
yeah. But you have said that the letter that came from the minister,
Yeah.
where he gave you 2 days within which to give him
Yeah.
the final report.
Yeah.
You have said that that letter, the contents of the letter were such that it was clear that the minister had in mind a preliminary report and
Yes.
another report, final report.
Yes.
Yes. Before complying, or was it asking that you should provide both reports to him? Is that what it was asking?
It talks about all reports.
All reports.
And the only report I was aware of in November
Yeah.
2040 was
Yeah.
the report I had signed.
Oh, and then that's the only report you then gave.
That's correct, Chair.
Yes. So it said all reports and not necessarily preliminary report and final report.
All reports, including preliminary and final
Oh,
reports.
okay. And then you just gave him what you understood to be the only reports.
Yes.
Yes. And did you immediately check with Kuba whether there was any report in the light of the letter of the ministers talk about all reports?
Kuba's view was that they were talking regularly to Mosing, and he was giving Mosing regular updates. There wasn't an issue of a specific report. So there were many updates given to Mosing and many directives issued by Mosing. My mind, in November, when we prepared the package for the minister, it's a continuous process of engaging with the prosecuting authority.
Yeah, but let me go back to my question.
Yeah.
Did you talk to Mr. Kuba to say, the minister has asked for all reports.
Yeah.
I just want to make sure that there are no other reports other than this one. Are there other reports that you know of? Did you ask him anything along those lines?
Not specifically
Not
along those
specifically,
lines.
yes,
My
yes.
impression is there's
Yeah.
that one report and there was correspondence and emails
Yes.
between them.
Okay, no, thank you. Oh, Mr. Procedural, I see we have gone
Yes,
past
thank you,
quarter
Chair.
past. Yes. Let's take the short adjournment and we'll resume at 25 to 12. We adjourn. Yes, you may proceed, Mr. Pretorius.
You will bear with us, Mr. McBride, the facts and the sequence of events as related in the various court applications in your statement and in the various annexures are, to say the least, very complex.
Yes.
They involve, as we've said, two levels of issue. One is the purpose of your removal, that of Dramat, and that of General Sabia, right? And why that occurred and what the outcome was. And then there's the complex set of facts underlying that. Unfortunately, we have to delve to some extent in those sets of facts. So we know that on the 22nd of December 2014, or thereabouts, General Dramat was placed on precautionary suspension.
That's correct. Yes.
I'm going to come to that in a moment.
Yeah.
Perhaps out of sequence, because we fast forwarded now to March 2015 when you were suspended, and we're dealing with your suspension letter.
Yeah.
And having glanced at your suspension letter, there are a number of allegations made in that letter which don't seem to bear any relationship to the outcome of the Worksman's report. It seems that the issues dealt with here, I'm not sure, form the basis of the recommendation in the Worksman's report which led to the criminal charges. But be that as it may, let's just go through the letter.
Okay.
In paragraph 7, the suspension letter says, and the minister says, when I invited you to explain your conduct regarding the aforesaid, you failed to disclose to me that there were two IPID reports, the conclusions of which were contradicting each other. Now, you've explained the sequence of events,
Yes.
Culminating in the final report. Did the minister speak to you before your suspension and invite you to explain your conduct?
No, only with the notice of intention to suspend, he asks for me to give reasons why not.
Right. Then he refers to the Sunday Times breaking the story or dealing with the leaks. What is said in paragraph 8? If you could put that on record, please.
Okay. I'm sorry, Mr. Pretorius, before that, let's go back to paragraph 7,
Yes.
where the minister says, when I invited you to explain your conduct regarding the aforesaid,
Yes.
and then he says you failed to disclose to me that there were two IPID reports, the conclusions of which were contradictory to each other. I understand him to be saying that prior to him taking maybe a provisional decision,
Yes.
that you may have to be suspended,
Yes.
which would be before he could write you any letter saying, tell me why I should not suspend you. I understand him to be talking about the period that would have preceded that time, namely the time when he wrote you that letter saying, tell me why I should not suspend you, or something like that. Is it true that he did invite you prior to that to explain your conduct regarding what he says the aforesaid?
No, Chair, he did not do that.
He did not do that.
No, he did not do it. It's only in the letter of
inviting you
notice
to,
of intention to
Yes.
suspend. And he had had a number of meetings with the department, but at this stage, it was a reference group. We had
Yes.
already given the report to the reference group.
Yes,
In particular, Advocate Matenjwa,
yes,
about the status of this investigation and where it's at. It's
Yes.
second half of 2014.
Yes.
Presumably the reference group gave the minister a report. Whether the reference group gave the minister the report of what we had conveyed to them or not, I'm not aware. But at that stage, if the report was correct, the minister knew what IPID's position was and what it had submitted to the NDPP. It increasingly appears to be that they didn't care about that version. They didn't care about that position. They had made up their minds because we did not tell the reference group anything else than what we had submitted to the NDPP. And I think, to give context, it's the first time ever a preliminary report went to a preliminary report before an investigation is completed, went to the NPA.
Yes.
And it never happened again.
Yes, okay, no, that's fine. Just in terms of what I'm really interested in terms of my question. The minister says, when I invited you to explain your conduct regarding the aforesaid, you failed to disclose to me, blah, 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 blah.
Yes.
So at this stage, all I want to know is whether, prior to him writing to you a letter along the lines that he was contemplating suspending you, make your representations, had he invited you to explain any conduct on your part regarding what he has dealt with above?
No, sir, no, Chair.
That had not happened?
That had not happened.
And you are sure about that?
Yes, I'm sure about that.
Okay. In the letter where he was asking you to make representations, if that's how he put it, did he include any complaint that he invited you to explain some conduct before and you did not explain anything? Was that included in that letter as far as you recall? Or you can't recall? This letter is signed 10th of March. Yes.
This one. I received it on 10th of March and suspended on the 25th.
Yes.
I don't recall any occasion where he asked me to explain anything.
Oh, no, I'm sorry. This is the letter where he is asking you for representations. I see
Yes.
at the end of the letter.
Yes,
This is the way, yeah. So obviously when he says in paragraph 7, so this is not the letter of suspension. I thought it was a letter of suspension.
Yes.
This is not the letter of suspension. This is the letter where he was in effect saying to you, he was contemplating suspending you. He was inviting you to make representations.
That's
So
correct.
obviously in paragraph 7, when he says he invited you to explain your conduct regarding the above, obviously he is talking about something that must have happened before that letter, if it did happen. But you are saying you are clear that prior to this letter,
Yes.
he had never invited you to explain any conduct on your part to him
No, he hadn't.
regarding the events he's dealing with in this letter.
No, nothing on the rendition.
Okay, all right, thank you.
To put the notice that we're dealing with in proper perspective, it appears from paragraph 6 that the minister is saying there is one report which recommends criminal charges against Generals Tramat and Sabia, and there is another one which doesn't recommend criminal charges. And those are two self-standing reports purportedly of equal status. Your evidence, as I understand it, is that there was a progression of reporting and investigation ultimately, and the final report, as you put it, effectively exonerated Generals Tramat and Sabia. Is that correct?
That's correct, yes.
Right. You also say that any changes in any reports,
Yeah.
in the progression of reports,
Yes, yes.
may well have been and in fact were perfectly justified by the results of further investigations.
That's correct.
And you say that that fact has never been given proper consideration.
Yes. Just to add, Chair, when we the answer to, after providing reasons and indicating to correspond, I do inform him on page 190 that we are going to court to deal with the issue for urgent application, and we deal with this. And the court application is launched 1 or 2 days after the letter is received. And in the court application, a unsigned report, the first report, is attached to it. So the first preliminary report is attached to the submission of documentation for the constitutional challenge in the urgent application. So it's not a signed one. The signed report of Kuba only arrives at the end of December. And so just in terms of sequence events, so the engagement with the minister is no longer via letters, it's now through the courts. And that's really the point I want to make. So there was now an understanding that there's an impasse. We have to approach the courts. And so the communication between IPID and the minister then was in effect after the launch of the application, either on the 12th of March, I say in the last, I have accordingly instructed IPID's attorneys, page 190 and 6, to launch an urgent application for appropriate relief, including interdicting you from suspending me. So the sequence at this stage is very back-to-back.
All right.
I'm only saying that for context of what is taking place.
I'm going to put a timeline before you, which has been very usefully prepared for me.
Okay.
During the break.
Okay.
Just to put things in a time context to make all the evidence that you give from time to time more understandable. But let's stick to the letter of suspension for the moment.
Yes, yes.
In paragraph 8, the minister refers to the Sunday Times story breaking about the existence of 2 IPID reports.
Yes, yes.
Mr. Pretorius, I made the mistake of thinking that this was the letter of suspension. The letter of suspension would be the one that actually suspends, isn't it? This was a letter saying I'm contemplating suspending you. I just don't want any reader to think when you are talking about paragraph 8 on this letter, you are talking about paragraph 8 on another letter that actually does the suspending.
Well, I will bear that in mind, Chair, and we will get to the next letter in due course. But this one sets out a number of reasons that are relevant, or not relevant, as the case may be, or relevant in the sense that they are not relevant.
No, that's fine. I'm just saying be alive to avoid confusion in case there is a letter of suspension later on. This is the one that we have talked about, and paragraph 8 is at page 187.
Yes. To be absolutely clear, Chair, at page 186 of Bundle YA is a letter addressed to Mr. McBride, the Executive Director of IPID, dated or signed on 10 March 2015, and it's headed Notice of Intention to Place You on Precautionary Suspension with Full Pay. We'll come to later correspondence later.
Yes, yeah.
But the motivation for the issuing of this notice is what we're dealing with and have been dealing with, short adjournment. I hope that clarifies it.
Yes, no, it does.
Then in paragraph 8, the minister says, when the Sunday Times broke the story about the existence of the 2 IPID reports in the Sunday Times of 1 March, you addressed a letter to the Parliamentary Portfolio Committee. What is the complaint there of the minister? And I think this puts into perspective evidence that you gave earlier.
The complaint of the Minister, Chair, is that I wrote a letter to Parliament requesting to explain the existence of the impression of two different contradictory reports.
Right. It reads, when the Sunday Times broke the story about the existence of the two IPID reports in the Sunday Times of 1 March 2015, you addressed a letter to the Parliamentary Portfolio Committee on Police, requesting them to convene an urgent Portfolio Committee meeting in order for you to explain to them the existence of the two IPID reports. Is that correct?
Yes, I did write such a letter and request.
When you addressed a letter to the Portfolio Committee aforesaid, you knew that I had already commissioned Worksman's attorneys to conduct an investigation on the existence of the aforesaid two IPID reports, and your conduct was designed to undermine my authority and oversight responsibility as the Minister of Police. Further, that such actions from your side put the commissioned investigation in jeopardy. Now, one can argue objectively about whether your letter to the Portfolio Committee to give you an opportunity to explain to IPID's supervisory body certain facts that had emerged in the press is improper interference with a separate investigation. I don't want to go into that argument. It's on the face of it, it can be dealt with quite simply. But what do you say about that?
Well, firstly, I was aware that there's Worksman, but the whole of paragraph 8 is spurious, and it's there isn't any misconduct. There is a commitment to account, and Minister should have welcomed that.
Yes.
He seems to say in paragraph 8, if I understand him correctly, his complaint seems to be you shouldn't have written to the Portfolio Committee about this issue while the investigation by Workman's, which he had commissioned, was pending. That's what seems to be his complaint. So in other words, he might not be complaining about you writing to the Portfolio Committee as such, but he seems to be saying while the Workmans had been asked by him to look into, among others, this issue, you shouldn't have done so.
Thank you, Chair. I understand the distinction. I'm not sure on either side, on either distinction, whether the Minister is correct. In fact, I know he's not correct. The Parliament represents the people. IPID has to account to them. IPID is requesting to account to them if there are perceptions of any wrongdoing or misconduct. In any event, ultimately, it's Parliament that must decide. And we find that later out in the Constitutional Court pronouncement. But I'm not sure what is really unhappy with me obeying the law, following through the due process of accountability with separation of powers. He seems to misunderstand his authority and how it is undermined by me engaging with the People's Parliament. And for me, I think it exhibits a bigger problem. And I'm not sure in a generous interpretation of paragraph 8. The Minister did not understand the notion of independence of IPID. He did not understand where his authority begins and ends, and he didn't understand the issue of openness. He preferred Parliament, he preferred Worksman to Parliament. He preferred a process that a private law firm exercises oversight over an independent oversight body rather than Parliament, which is the real oversight body of that independent body. Choosing a private law company whose job is not investigations or of holding people to account over Parliament, for me, indicates, at very least, at very best, a misunderstanding of how the state and government works.
So, is part of your comment that arising out of the independence of IPID and the fact that it was duty-bound to account to Parliament, and that Parliament is different from the executive, if there was an issue that you believed the portfolio committee should be informed about, as head of IPID, you were within your rights, and maybe you will say you may have been obliged to actually bring it to the attention of the portfolio committee and ask for an opportunity to brief the portfolio committee. That's part of what you are saying.
Indeed, Chair.
Okay.
Put differently, what the Minister appears to be saying in paragraph 8 is that the duty that you have as head of IPID to report to Parliament in terms of the oversight mechanisms in the Constitution is somehow suspended because he is conducting a private investigation.
Indeed, Chair.
And of course, the corollary of the Minister's attitude is that he is entitled to interfere with that oversight process at his own behest by appointing a firm of private attorneys to conduct an investigation.
Indeed. He
But
believes-
anyway, those are arguments we can
Yes.
deal with later. It's just that those are the various sides of the story, the Minister's side and your side, as I understand it.
Well, no, Chair. It's not my side. The Constitutional Court said so.
Yes,
That the Minister is wrong.
correct.
Yeah. And
And we'll come to that in due
Yes,
course. Perhaps I was unfair to you to say your side of the story. It's not a story of fact. You rely on constitutional provisions and the application by the Constitutional Court in relation to those provisions.
thank you, sir.
Then in paragraph 9, he says that, and of course, what is interesting is that although Worksman has been appointed to provide a report on the very facts which are the subject matter of this letter predates, and the conclusions in this letter predates the issue of the Worksman's report.
That's correct.
In paragraph 9, a different matter is dealt with. Would you put that on record, please?
He says here in paragraph 9, you are also alleged to have interfered with the investigation. You have also alleged to have interfered with the investigation I have commissioned by failing to grant Mr. Innocent Kuba permission to meet with the investigators to assist them in shedding light on the existence of the two conflicting reports, both of which were signed by him. You also instructed lawyers to inform the investigators that Mr. Kuba will not meet with them. When you conducted yourself in the aforesaid manner, you had intention to interfere with the investigation, and given the fact that you already conflicted, because the second report dated March 2014 was also co-signed by you.
I'm not sure which investigation is being referred to here, but perhaps you could explain your response and understanding of what is being said here.
He was referring to the Worksman's investigation. at the stage when Worksman did not actually communicate with me, although I was aware they were. And then I indicated that Worksman should come through me. I'm not sure how did I do it, but that was the intention. It was Worksman. I had a problem about the independence of IPID with a private company appointed by the minister to be calling in individual investigators, and in this case, the chief investigator of the matter, behind my back. And it was also at the same time when the minister was contacting Cuba and to actually even fly him down to Cape Town at his own expense. So it's in that context where I said they should come through to me, and you are jeopardizing the independence of IPID. So indeed, I initially refused Cuba to participate in whatever Worksman was doing.
Did he finally participate?
Indeed he did, and so did I. And later on in my letter in response, I say I don't have a problem with that if that's the issue you are concerned about.
Right, so is it correct that you did not grant Mr. Kuba permission to meet with the investigators?
Absolutely.
You've given your reasons.
That's correct.
Then paragraph 10, it says, during the week of the 15th of February 2014, you visited the provincial offices of the DPCI in Gauteng and removed from Major General Sabia's office a device, the description of which is yet unknown, from the safe where Major General Sabia had kept it under locks. What is that allegation all about?
Okay, thank you, Chair. So at some stage during the process of suspending General Sabia, two superintendents, or colonels, I think they were then called, arrived at Sabia's office in his absence and said they were sent by Mdluli, that is General Mdluli, to take away the encrypted facts in Sabia's office. So Sabia's personal assistant contacted Sabia either through lawyers or directly, but in any event, Sabia called me and his lawyer, Mr. Ngwashu, contacted me, in essence, to say a crime is about to be committed in his office. He is suspended, he doesn't have a say in his office, but the person who he was investigating has now sent two people to his office to remove a device. He therefore requested that a crime is about to be committed. Can we, as the body dealing with investigation of police conduct, intervene and take custody, take possession of that device for safekeeping? And that was what we proceeded to do, and we indicated it's part of our investigation into systemic corruption, and we went and handed over our letter, and the police then handed over the stuff to us. It was a device, it was something that encrypts faxes. It's a old technology. In any event, prior to this letter reaching me, and the exact timelines I will get right, the minister summons me to Parliament, to his office at Parliament, his parliamentary office.
Summons to who? I'm sorry? Summons to who?
Myself,
Oh,
Chair.
okay.
When I arrived at the office, I was made to wait outside, and there were two other gentlemen with me. I could sense they were police, but I didn't know them. recognized him, and then all three of us were then invited into the minister's office. And the minister's desk is a bit of distance away from his boardroom table. And as he got up, he made us sit and wait a while. In fact, coffee was ordered, and he carried on there, doing whatever he was doing on his table. Then he got up from his table and started verbally abusing me, all the way until he reached the board table, and sat down and continued to say, anytime you conduct a raid, you have to inform me beforehand. I listened through it all, and then when he had finished and he had ventilated enough and he was out of breath, I then asked him, who is this gentleman in front of me that you're abusing me in front of? And then he momentarily cooled down and said, I thought you knew each other. This is General Ntlemeza. That's my first time meeting General Ntlemeza. And we spoke, and I explained the circumstances to him of how the device in General Sabia's office was taken. And I explained to him that it was then handed over to the State Security Agency. He then seemed to relax, and he said, myself and General Ntlemeza must work together. So General Ntlemeza gave me his phone number, and I exchanged my phone number with him, and it was at the period where, I think it could have been a Thursday when I met with him, and then the Wednesday there was, at Parliament, there was a jamming of cell phones. Then he, as he was putting on his coat, he made a joke to me and said, I know what you have done with that device that you took from Sabia's office. You went to Parliament and you jammed all the cell phones. So I had relief. I thought, okay, it's been resolved. It's a joke now. He accepts my explanation. The next thing was this letter. So it was, I thought it was okay. I even went back to Mr. Sissoko and said, I think it's going to be okay now. And very soon after, maybe 2 or 3 days, this letter came. Yeah.
So, are you sure, therefore, that in that meeting, he didn't extend to you the invitation that he talks about in paragraph 7 of the letter?
Absolutely.
He did not.
He did not. He spoke only about the raid and the device in Sabia's office.
Okay.
And he seemed to be happy and satisfied with my explanation.
Yes.
When he left.
So, if I understand you well, the first part of what he said to you at that meeting was abusive.
Absolutely.
But the last bit which he said to you was like he was just joking with you.
Yes, sir, that was my distinct impression.
Yes, okay, thank you. Yes, Mr. Pretorius.
The event described in paragraph 10 is alleged to have taken place during the week of 15 February 2014. Is that correct?
Yes.
You were summoned to the office of the minister together with General Ntlemeza and one other a few days before the 10th of March 2015, you say?
That's correct. I might have the number of days not accurate, but it was certainly in terms of sequence of events after the device was taken into possession and before this letter of 10th of March.
That's almost a year later. Am I correct? Or am I missing something?
No, sir. he's made a mistake at paragraph 10. It should be 2015.
Ah, okay. So
Actually, you were not, you had not started at IPID by
2014.
February 2014.
That's
because you
correct,
only started in March.
That's correct, Chair.
Yes.
all right. Well, that explains my own difficulty there. And in any event, what is said in paragraph 10 is that it was your intention to tamper with evidence that might incriminate Major General Sabia, yourself, and or, it says, Lieutenant General Dramat. Do you have a response to that allegation?
There's no basis for it. It's he had got my explanation when I gave him explanation of the circumstances of taking into custody of this. I'm not sure how would I implicate myself with General Sabia in any way. I was not at IPID when or ICD when the investigation into rendition started. Communication with General Sabia was through his lawyers. I met him in 2014 once on a joint investigation in the company of other people in the boardroom. So I'm not sure, there's no basis for this. I think that's the paragraph 10. He was again interfering in any event in the work of IPID.
When you explained to the minister in that meeting where General Ntlemeza was the circumstances under which you had taken possession of the device from, excuse me, General Sabia's office, did he seem to have anything he was not accepting about that explanation? Did he seem to not to believe what you're saying? Did he seem to have any problem, or did he seem to accept?
Chair, the person who got up from his chair and moved towards the boardroom table, abusing me by the time he reached there and continued, is a different person that left the room.
After you had given the explanation?
Yes, sir. Yes. And my impression was that General Ntlemeza had complained about taking the device from General Sabia's office, because perhaps they had wanted the device for some purpose. But they should have done it and not get General Mdluli's people to do it. And they should have had provided paperwork like we did to take possession of it. We even signed a receipt when we took the device.
Was that device relevant to the investigation that General Sabia may have been conducting in regard to General Mdluli, as far as you understood what you were told by Sabia?
Yes, Chair, because that was the concern from General Sabia via his lawyer, they are concerned about that a crime is about to be committed. It certainly was in no way connected to IPID's investigation into rendition, because the final report by February 2015 was already submitted.
Your reply to the letter is dated 12 March 2015. Do you see that?
That's correct, Chair.
I don't want to go through the whole of the reply. It may be that the real issue here is that on whatever basis the suspension was found by the Constitutional Court to be undue interference in the independence of IPID.
Yes.
That's the more general issue. But in paragraph 3.3 of your letter, let's start with paragraph 3. You summarize your response in paragraph 3, and you refer to the affidavit that you have deposed to in court proceedings to contest the notice of suspension. Do you see that?
Yes, that's correct.
Paragraph 3.1 and 3.2 are general denials of improper acts on your part.
Yeah.
But 3.3, you say the minister was at all relevant times fully aware of the existence of the preliminary and the final IPID reports. As more fully set out in the affidavit, the minister has chosen to rely on recommendations contained in a preliminary report. I remain available to address any concerns that the minister may have in relation to the preliminary and final reports.
Okay.
On what basis were you able to say that the minister was at all times fully aware of the existence of the preliminary and final reports?
If memory serves me correctly, the affidavit that I had prepared for the High Court was also given to the minister. And that's why it refers to and also the fact that in the ministry, we had sent an info note on my first week at work as to the status of the report on rendition. So it was my info note that was given to then Minister Mtetwa. So there would have been in the ministry that report, but in addition, I included in my my application to the High Court, which was launched on the same day. And if I remember correctly, I would have included the affidavit to the minister.
I'm sorry, Mr. McBride, I'm interrupting you.
Yeah.
But the question is, you said in the letter that the minister was aware at all times. And the question is, on what basis were you saying, as at the 12th of March 2015, that he had been aware at all times of the two reports?
One of the reasons was that in his letter requesting it a few months before, requesting document, he had referred to preliminary reports and final reports.
Yes.
In his letter,
yes,
in November, I think it could have been 24th of November, 2014. And also the fact that we attached this letter. So this letter is, I see written there, was an attachment to the affidavit
in the High Court application.
That's correct, sir.
Yeah. If it was an attachment to the High Court affidavit, it would have been written either before the High Court affidavit was done or on the same day.
That's absolutely correct, because
Yes.
the application was a few hours, even simultaneously, with a letter to the minister.
So what was contained in the High Court affidavit can't explain the basis on which you said the minister had been aware of the two. So I think what's more important is to look at, prior to the writing of this letter, what it is that you, gave you the basis. But you have said that his letter, and it said maybe if that letter is here, we should go to it once and for all.
We're looking for it, Chair.
Yes. Oh, okay. All right. Is there anything else that would have made you believe, as at the time you wrote that letter, that he was aware at all times of the two reports, or is it only what he wrote in his letter?
Well, there would be, and I can't remember specifics.
Yes, yes.
But in the letter in which I'm replying to, he talks about two reports.
Yes.
he writes to me asking for 2 reports. The info note sent to Minister Mthethwa talks about preliminary and final reports.
Yes.
And the fact that the investigation is complete, but the evidence has been finalized.
Yes.
Now, the ministry is the ministry. It's not the ministry,
Yeah.
in my
It's the
understanding.
same office.
Yes, after Nhleko comes. The practice is, and we wrote what we call handover report. We prepare for ministers when there's a change of administration and there's a new person. It would have been included in there. This whole saga is to say there existed preliminary or first reports and somehow attach a sinister motive for its existence. And that's the narrative that's been pushed, including through the media. And that's the narrative we refer to when we make our joint statement, that is Dramat, Ivan Pillay, and myself. We talk about this modus operandi of which we explain in here, and which occurred in other institutions, anti-corruption institutions. So, in essence, those would have been the reasons why I would, and they would have come to the conclusion he knew. In any event, he had received a report from the reference group, which we briefed about the final report and the communication with Musing. And what are they doing, in essence, Chair, is clutching at straws, even though the straws don't exist. So it's making issue out of something. So initially to write a letter to me about the rendition report. Later on is to tell me about a device that in the course of our operations we're taking into possession. It's now as if they're making it up as they go along. So find the reason. And that is what, and it grows. Later on, by the time I do disciplinary, there's about 8 charges or something, if I remember correctly.
Okay.
So the initial reason, which gave me notice of intention to suspend me, starts growing. As in a very short space of time, 2 or 3 months.
Yes. We could spend a long time debating the merits or demerits of any particular charge or contemplated charge or reason for suspension. I just want to return to the point. Were any of the reasons given in any notice of suspension or in any disciplinary charge or in any allegation in any report or in any finding of any report finally successful in relation to the termination of your services or the prosecution on a criminal basis of you?
Never, Chair.
In any event, you say in paragraph 3.3, the Minister was at all relevant times fully aware of the existence of preliminary and final IPID reports.
Yes.
You've been questioned by the Chair in that regard. You mentioned the reference group.
Yes.
That group had access to and investigated all documents relevant to the IPID investigation, I presume including the docket in the possession of the NPA.
I cannot comment on
All right.
what they knew or what they had access to at the NBA.
Yes, but in any event, on proper investigation, one could have reference to the contents of the docket, and everything is in the docket. Nothing is concealed in the docket.
If I can just add also, there is also a misunderstanding about how the criminal justice system works from the Minister and his people. Because the docket contains the evidence and exhibits and reference to the exhibits. That's the decision upon which to prosecute or not prosecute rests. And they are splitting hairs. They're trying to find something, and that's my impression anyway. So, thanks.
So part of what you are saying is, if one appreciates the distinction between the evidence that's in the docket, which is the evidence that's put into the docket after an investigation, and the report.
Yes.
If one appreciates the distinction about the status of these two,
Yeah.
whatever may have been done, whatever a report says, in the end really shouldn't make much difference. And you must just tell me, I'm testing whether that's what you're saying, shouldn't make much difference if in the end you look at the evidence in the docket and you are the person who must make a decision, because your decision must be based on the evidence and not so much on the report.
That's absolutely correct, Chair.
Yes.
That's my position.
Yes, and that would be your position whether we are talking about the interim or preliminary report or the final report.
That's correct.
Is that correct?
That's correct.
That in the end, it's the evidence that must count.
Absolutely.
And what is said in the report, whether you are the prosecutor in the NPA who must make a decision, or you are the minister, in the end, really, your final decision about what should happen or what is being said should be what's in the docket by way of evidence.
Yes, that is correct. Regardless of what the opinion
Yes.
of an investigator is,
Yes.
it's the evidence
Yeah.
that decides.
Yeah.
As I said earlier, very often an investigator has a particular position.
Yes. Yes.
As a final report, the final reports, but the NPA doesn't agree with it.
Yes. Yeah.
Or vice versa, in certain circumstances, they say, do not prosecute. The NPA goes ahead and prosecute. That is their job.
Yes.
So, to answer your question directly, it is the evidence upon which a decision is made, not the interpretation, misinterpretation, misunderstanding of the value of the evidence by an investigator.
Okay.
So just to summarize that point, because it does deal with a lot of these questions at a level of principle, and may allow us to spend less time on each and every detail in the report. I stress may, for the present we'll have to consider the position. But in essence what you're saying is IPID collects evidence and provides for the use of the NPA an opinion, which is the report on that evidence.
That's correct.
The responsibility for prosecution, the responsibility for assessing the evidence in the docket, and the final decision on whether or not to prosecute remains with the NPA.
That's correct, Chair.
And as a general proposition, don't blame me for my opinion. That's what, make your decision on the evidence. If you want to have regard to my opinion, have regard to it, but in the end, remember that you must make your decision on the basis of the evidence. That's part of what you're saying.
That's correct, Chair.
Yeah.
And even to take it further, if I'm incompetent as an investigator, then I must get trained, not persecuted. That's really the...
In other words, you might have a situation where you don't agree with my opinion, but that doesn't necessarily mean that I'm wrong. That doesn't necessarily mean that you are right. And it might not necessarily mean that my opinion is based on incompetence on my part. Yes. But there may be situations where the opinion I give is so bad that you think it reflects incompetence, in which case you might be concerned about that, and there may be a way as to how that should be dealt with.
That's correct, sir.
Okay.
Yes. All right. In the following paragraph on page 190 of your response to the notice, you deal with the instruction to your subordinates within IPID not to deal with the minister's investigation. Do you see that in paragraph 3.4?
So I have it, sir.
In fact, what you say is the minister's investigation into IPID and the NPA is, however, impeding on IPID and the NPA's independence and expertise. And you say, therefore, you've acted responsibly.
That's correct.
So the minister wants to prevent you from reporting to IPID, and your response is, well, you're not going to cooperate with the minister's investigation.
That's correct.
Ultimately, you did, though.
Yes, I did. In that last sentence, I remain willing to engage with the minister in respect of the investigation, and specifically to ensure that there are sufficient safeguards to protect IPID.
Yes, and ultimately, Sissoko and others testified before Worksman's.
That's correct. We were interviewed by Worksman, Mr. Kuba, Mr. Sissoko, and myself.
All right. If we may then deal with what I intended to deal with earlier, and my apologies if it's out of sequence, and in a moment I'll deal with the timeline drawn up in haste but expertly by my junior chair. Let's go to page 448, and this is merely a resort of convenience to the summary of facts in the judgment of Prinsloo J. relating to Dramat.
Yes, sir.
The contemplated disciplinary action against General Dramat.
Have you moved to another bundle, Mr. Pretorius?
I'm sorry, Chair.
Are you moving to another bundle?
I am, Chair. It's at page 439, bundle YB.
YB for Beatrice. Okay.
It's the second bundle, Chair. Should be.
And the page number again?
448.
448.
Well, perhaps we should just place this in context and deal with page 439.
Okay.
Not going to go into detail in relation to the application, merely to refer to the facts summarized in that application, about which in any event there will be direct testimony in due course. But this is important for the major points that you wish to make at the higher level. At page 439, we have the judgment of Prinsloo J in the matter between the Helen Suzman Foundation, applicant, the Minister of Police, Lieutenant General Dramat, Major General Burning and Klemeza, and the National Commission of the South African Police Service. This was a challenge to the disciplinary proceedings, or contemplated disciplinary proceedings against the second respondent, Lieutenant General Anwar Dramat. Is that correct?
That's correct.
I just want to go back to paragraph 10 on page 448. At issue in this particular case, firstly, was the locus standi, or the standing of the Helen Suzman Foundation to deal with these issues at all. And that's largely where the judgment goes, but there's a summary of facts on page 448 and before and after. But in paragraph 10, just to remind ourselves, on the 23rd of December, the Minister wrote to Dramut informing him that he was placing him on precautionary suspension with full pay and benefits with immediate effect. And then there's reference to the powers under which that is done, which we needn't deal with at the moment. But in paragraph 11, the case in summary of Dramut as at the 24th of December 2014 is set out. He says in a letter addressed to the Minister, amongst other things, what is quoted in paragraph 11 of the judgment. He says, I have for several months reflected very carefully on the issues that have unfolded in front of me. I have consulted my legal representatives and I have been advised of my legal remedies. I respectfully point out that the tactical backpedaling from the initial notice and the current reliance on the Public Service Act and Public Service Regulations and SMS Handbook is a clear indication to me that no matter what steps I take to defend my position, a decision had already been made from the outset to remove me from my position. We needn't go into that background, it'll be explained in due course, but it seems that at various times different statutory powers were relied upon by the Minister.
That's correct. Yes.
Paragraph 4, having seen our country enter into a democratic phase, I felt that I could contribute in a meaningful way and continue to develop the principles which I fought for and for which I was imprisoned. Paragraph 5, my appointment as the head of the DPCI, that is the Hawks, I perceived at the time was based on my credentials, my level of expertise, and the fact that I respectfully believe that I have always acted with integrity in the manner in which I deal with people and investigations. Paragraph 6, no doubtedly, as it says, you are aware that I have recently called for certain case dockets involving very influential persons to be brought or alternatively centralized under one investigating arm, and this has clearly caused massive resentment towards me. Paragraph 7, I can unequivocally point out that I am not willing to compromise the principles that I have always believed in. I am not willing to be agreeable or compliant insofar as I would then be acting contrary to my own moral principles and also contrary to the position in which I was appointed. Paragraph 10.1, the quotes here skip a few paragraphs of the letter. The so-called Zimbabwean rendition investigation is a smokescreen. There are no facts whatsoever that indicate that at any given time I have acted illegally or unlawfully. Most certainly there has never been any evidence whatsoever that I have in any way interfered with any potential witnesses or attempted to jeopardize the investigation against me during the past few years. And then he takes issue in the following paragraph.
4 years, eh? 4 years.
Past 4 years. Did I say few years?
Few, you said few, yeah.
My apologies. Past 4 years. Then he reserves his rights. He contests the validity of the notice of precautionary suspension. He then says in paragraph 12, I am also aware that in the next 2 months there will be a drive to remove certain investigations that fell under my watch, reallocate certain cases, and that unfortunately certain sensitive investigations may even be closed down. This is something I have to live with, that I have to live with. He then comments again on the investigation into the rendition case, and then he says that he wishes to apply to the National Commissioner to approve early retirement and invites a joint consensus-seeking process. Firstly, did you know of any investigations in which General Dramut had been involved, which were of a sensitive nature at the time action was taken against him?
No, I was not aware of that
All right.
at this stage.
We will refer to another document shortly which deals with that. And do you know whether General Dramut ultimately accepted a deal involving early retirement?
Yes, I became aware at some stage after it happened. Yeah.
All right. There's further evidence recorded in the judgment, but I'd like at the moment to deal with another matter. Although it's a press report, it does refer to other correspondence, and there will be direct evidence of these facts in due course, but it's important to place them into context now. So would you go to page 490, please?
I have it here.
There's an interesting commentary there on matters raised in the opening, the demise of the Scorpions and the comparative performance of the later institution, the Hawks. But under the heading, "What is the story behind Hawks Chief Anwar Dramut's suspension?" the reporter says at the end of paragraph 2, Dramut was investigating high-level corruption and was becoming an inconvenience to those with something to hide. Dramut himself has argued that the accusations of illegal renditions is just cover for his investigations into high-level corruption. There will be evidence in due course as to what General Dramut was investigating. But let's go first to page 491. There is a quote from a Mail and Guardian article which states in the middle of page 491, in his December 24 letter to Police Minister Nkosinathi Nhleko, following his purported suspension, Dramut wrote, "No doubt you are aware that I have recently called for certain case dockets involving very influential persons to be brought or alternatively centralized under one investigating arm, and this has clearly caused massive resentment towards me." The report continues, new claims have emerged suggesting the controversial security upgrade at President Jacob Zuma's Nkandla homestead was at the apex of the investigations Dramut perceived as highly sensitive. Mbogani has been told by a source familiar with the matter that in December 2014, Dramut called for the Nkandla dockets, currently under the control of the Divisional Commissioner for Detective Services, Vinesh Munu, to be transferred to the Hawks. The South African Police Service has never denied this allegation, merely stating that National Commissioner Ria Piyecha and Dramut never discussed the Nkandla investigation. A Constitutional Court ruling 2 weeks earlier made it clear that Dramut alone has the authority to decide which cases the Hawks should take on. The source said that following his suspension, Dramut told colleagues that his first notice of the intention to suspend him arrived barely 2 days after he had asked for the transfer of the Nkandla dockets. Do you know anything about those facts?
I'm not sure at which stage I was aware, but I did become aware at some stage that was the assertion.
Then there's reference to the litigation which followed, which we needn't go into now. But that is just to place in context and in sequence the evidence which you have given and which will be given in relation to the rendition saga, the investigation into the rendition saga, and the reliance on those investigations to deal with the employment of General Dramat.
That's correct.
A piece of evidence about which there will be testimony in due course. Chair, if I may then intervene before we return to the statement, to place before you, which may be useful, hope it is, a timeline. The notice
I'm not going to make a note. I assume you might hand something up that reflects that.
Yes, we'll have it typed out, and
Yeah.
perhaps even by 2 o'clock.
In
we'll
due
get it
course,
to you.
that's fine.
It's not necessary to
Yeah.
put it on record. Or do you want me to put it on record?
No, I'm saying you can say it, but I won't make notes here.
Yes,
But
sure.
later,
I understand.
Later on, you
Indeed.
can give me something that reflects that.
Indeed, Chair.
But you can just tell us.
Thank you.
Yeah.
On the 9th of December 20, and by the way, this doesn't purport to be a comprehensive chronology,
Yeah.
and perhaps it's a good idea, Chair, to prepare one for you so that all the evidence
Yeah, that would be
over
helpful.
time
Yeah, that would be
could
helpful.
be better understood and placed into a time sequence and
Yeah,
context.
that would be helpful.
But for the present, I have a note here which says, I will update and type the timeline. So your mind was ready.
Your junior is being very helpful to
Yes.
you. Yes.
On the 9th of December 2014, there occurred the notice of intention to suspend Dramat. On the 23rd of December 2014, the notice of suspension of Dramat was actually issued.
Yeah, it's very interesting. It's around Christmas time.
Yes, 2 days before Christmas. On the 23rd of February 2015, Minister Nhleko appointed Worksman to conduct the investigation. On the 10th of March 2015, there was a notice of intention to suspend Mr. McBride. On the 24th of March 2015, the notice of suspension was actually issued. On the 31st of March 2015, Minister Nhleko visited IPID and addressed employees at IPID. And we have a record of that. We will deal with that in due course. On the 17th of April 2015, Mr. McBride was interviewed by Worksman. On the 23rd of April 2015, Mr. Kuba was interviewed by Worksman, and the final report of Worksman was issued on the 24th of April 2015. Thereafter, criminal charges were laid against Mr. McBride, and on his appearance in court, they were withdrawn. But that is a chronology that will be expanded on and
Yeah,
presented
thank you.
to you.
We're going back to Exhibit YA.
Yes, YA at page 7, Chair.
Thank you.
The final event, which I've just mentioned to the Chair, is dealt with in paragraphs 31 to 33 of your statement.
Okay.
That's correct, Chair.
What happened on the 15th of March 2016?
If I remember correctly, that's the day on which we were arrested.
And what were the charges?
Fraud and defeating the ends of justice.
You say here that those charges arose out of the recommendations of the Worksman's report. Have we got the correct dates here? 15 March 2016, which
Yes,
is
that's correct.
almost a year after
That's correct.
the Worksman's report was issued.
That's correct.
You say that, well, our chronology says that the Worksman's report was issued on the 24th of April 2015,
That's right.
and you were finally charged on the 15th of March 2016. Is there any explanation for that delay? Were you in litigation at that stage?
If I can just explain, after Worksman's report was a disciplinary process immediately after. So that would be May, maybe first week in May. And charges were laid in May, criminal charges, by Minister Nhlego, and an officer from the Eastern Cape, Colonel Gwai, then opened up an inquiry, and he was from CATS, Crimes Against the State, against myself, Kuba, and Sissoko. And it took a year for this to be brought to court. And during the period, I just need to mention it so the Commission can understand the invasiveness and the malice attached to what went on. At the same time, my understanding is that charges were also laid against, I'm specifically looking at timing, in 2015. In this, I think it was March or May, I'm not sure, but in that period, I think even in this, within 10-day period, was laid against, and it's out of my purview, but it's Minister Gordhan at the same time. I'm coming back to the hypothesis which we developed amongst ourselves, a consensus of affected people in terms of a time frame. Things had to happen by certain times. That was our impression, and circumstances seemed to bear our suspicions out. In any event, there was a year that took it for us to be charged. There was a warrant of arrest issued for us before we had given warning statement, and we were asked to give warning statements and to come into the Hawks' office. Now, I just want to give context which might not see relevance now, but what So we were asked to come in at that same period, but the warrants of arrest were already prepared for us between Mahema and Dr. Tori Pretorius. Indeed, it's Dr. Tori Pretorius who took the decision to prosecute us. And we were unaware that there were warrants of arrest when we went to provide our warning statements. And it could have been a Wednesday or a Thursday, just preceding this, the day of arrest. And we provided the warning statement in the form of all the litigation that's taken place between ourselves and the minister, and the disciplinaries, and the fact that even the labor court had, or the labor court was seized with the idea of suspending disciplinaries until the constitutional matter had been resolved, if I remember the correct sequence. But we gave every document to General it was then Colonel Xaba. We gave me everything, and in the in the warning statement, one makes provision for the warning statement. We referred to all of that. I think it was 4 or 5 lever arch files between myself, Sissoko, and Kuba. So this is the context. Understand that there is litigation about these issues and there's constitutional issues about this. So be aware of it. And the explanations have been dealt with in these various affidavits, and you will find them there. By Sunday, a few days afterwards, in my experience and my view, insufficient time to go through 4 lever arch files. We were told we must appear on the Monday, that we will be charged. And we went to court and we were told to go to the client customer center, previously known as the charge office, where we were charged and put in cells until we appeared in court a few hours later. So it might seem like a wonderful, nice thing to do and normal course of events, but we were in essence the mainstay of an independent organization that exercises investigative oversight over the police of South Africa. And this is what was done to us.
And this was on the same day that you went in to give your warning statements, your arrest.
No, Chairperson, it
That
was a
was
few
on
days
another
after,
day.
but we were
Okay.
notified on a weekend on the Sunday. But already the warrant of arrest
Were ready.
was in their possession when we came and given our warning statement.
Okay.
So, in fairness, it's about 2 or 3 days later, we are given notice that we must present ourselves at the court, which we did. So I'm giving that context because it would appear to be a normal process of people that transgress the law. But in this instance, there's a whole process. It's a DPCI, supposedly independent. The head is knocked out. He's replaced with someone. The person who replaces the head of DPCI is ultimately the commander of those who then arrest us. So for us, the link, at least in our own minds, one can look at it objectively, is that there's causality between all these events. And 2016, Dramatis, he's out of the police. He takes early retirement. I'm assuming when he took early retirement, everything was okay. He's gone, he's out of the system, and yet they still follow up persecuting him with criminal charges also, which are later than all these charges, with all this drama, with all of the arrest, charges are withdrawn again. And the basis of the charges against IPID people is reliance on the Worksman report.
Are they withdrawn on the same day, first appearance, or a second or later appearance?
No, Chair, charges were withdrawn on 1st of November 2016.
Okay, but you can't remember whether that would have been second, third, or fourth appearance or such?
It would have been the 4th or 5th appearance.
Okay, okay.
All right. Can we come back to paragraphs 31 to 33 after the adjournment, Chair?
Yes, thank you. We'll take the lunch adjournment and we'll resume at 2. We adjourn.